Welcome back to another episode on legal costs. The final scale of costs which we need to discuss is that between attorney and own client. Attorney and own client costs are those costs which the client has contractually undertaken to pay to his attorney. Remember, the fee structure of the attorney is usually agreed upon prior to or during an initial consult. As you will know by now, attorney and own client costs are generally only awarded when a court strongly disapproves of a litigant's conduct. Attorney and own client costs may sometimes also be awarded where the parties expressly agree that costs will be payable on such scale should a dispute arise in terms thereof. Despite what you may have been told, an attorney and own client costs award does not mean that the client's entire legal expenditure will be recovered from the opposition. In Aircraft Completion Center, Pty Ltd vs. Rousseau and others of 2003, the court found that there is essentially no difference between an attorney and client costs award and an attorney and own client costs award, as against an opponent. This was confirmed in Society of Advocates of KwaZulu-Natal vs. Levin, where the court stated that an attorney and client bill will be taxed more strictly when taxed against an unsuccessful party than when taxed against the attorney's client, subject to the general rule that each bill will be taxed with due consideration of the factors relevant to the assessment of its reasonableness. In an inter-party taxation, where the attorney and own client scale is applicable, the matter is simply referred back to an intermediate scale as identified by Tundel AJ in Null vs. Waterberg Landbouwers Coöperatief Vereniging. In this case, the intermediate scale is described as a scale between party and party and attorney and own client. What is meant by the latter scale is that which a party is to pay to his own attorney and can be called a pure attorney and client scale. In such a bill of costs, the client is liable to pay his attorney all costs at an agreed tariff, except where it can be said that the attorney has overreached his client. In an inter-party taxation based on attorney and own client scale, on the other hand, the intermediate scale is applicable and is intended to prevent injustice to the costs debtor. For practical purposes, there is no difference between an attorney and client taxation and an attorney and own client taxation as between parties. Should a need for a new category of attorney and client taxations arise, it is for the Rules Board and not for the court to introduce it. In Kutsia vs. Taxing Master, this is a case from September 2012, the court stated that the payment by a client to the client's own attorney is not aimed at a full indemnity, but rather is aimed at payment of a reasonable recompense for services rendered. In exercising the discretion to determine a reasonable rate for time charges for services rendered, the practice is to have regard to fees charged by other legal practitioners, the seniority of the attorney, the time taken over the work, and the nature of the work performed. In the case of Conrad Kruger Inc. and another versus Taxing Master and another, March 2020, the court held that the attorney and own client scale necessitates the taxing of the fees at a higher rate than those allowed in the tariff. The court further stated that it was in agreement with the Taxing Master in that Rule 69.3 clearly does not apply to an attorney and own client cost bill. For ease of reference, Rule 69 subsection 3 provides that, save where the defendant or respondent is awarded costs, the tariff of maximum fees for advocates between party and party referred to in Part 4 of Table A of Annexure 2 to the Rules for the Magistrates Court, hereinafter referred to as the tariff, shall apply where the amount or value of the claim falls within the jurisdiction of the Magistrates Court, unless the court, on request made before or immediately after the giving of judgment, otherwise directs. In terms of Erasmus Superior Court practice, the tariff in Rule 70 is not binding on attorney and own client scale costs and is merely a guide for taxation. Although the tariff in Rule 70 is intended for the taxation of party and party costs, the taxing master must use it as a guide in the taxation of penal costs to be paid by a defeated adversary, which is costs on an attorney and client scale, and those due to a client's own attorney, which is attorney and own client costs. The taxing master has a discretion, when taxing any bill of costs, to depart from the tariff on the basis of what is fair and reasonable, and in particular with reference to the express provisions of Rule 70, subsection 5. When taxing a bill between an attorney and his own client, the taxing master is empowered, and indeed in duty bound, to satisfy himself that the fees claimed relate to work actually authorized, and that the fees charged are reasonable. If an attorney has agreed with his client in respect of certain work a remuneration higher than that laid down in the tariff under this rule, the taxing master is empowered to inquire into the reasonableness of such an agreement. A taxing master is entitled to become fully informed, either by own inquiry or by evidence placed before him, of ruling rates and current practices. In light of the above, there is clearly much uncertainty about the attorney and own client scale, and opinions seem to differ amongst judges, especially when it comes to the taxation of such costs. It can still be deduced, however, that this scale is most favorable to a successful litigant, despite the fact that said litigant will still not be able to recover his entire legal expenditure. And that's it for attorney and own client costs. Next week will be the final episode on legal costs, which we will discuss the actual process of recovering legal costs. So definitely keep your eyes peeled and make sure to subscribe. Cheers for now.